Good morning, everybody. Sorry about that. My uh, audio was on mute. So again, my name is Amber Hines, and today we're going to be talking about Medicaid basics, understanding the asset and income rules in your state. I want to wish everybody a happy new year. I hope that you had a great holiday season. In February, we're going to have a guest speaker, attorney Todd Watley, who's going to be giving you a more in-depth view of the Medicaid planning techniques in each of your states. But today we're going to be doing a high-level view of the income and asset limitations in each of your states. And I hope that everybody gets something out of today's webinar. My name is Amber Hines, and we are going to, well, if you have any questions during today's webinar, feel free to type those into the questions tab of the GoToWebinar dashboard. And then also, if you're interested in a copy of the handouts from today's presentation, feel free to download those from the handouts tab of the GoToWebinar dashboard as well. My name is Amber Hines, and I have been working with elder law and estate planning attorneys for the last 15 years on Medicaid compliant annuities, as well as pre-planning for clients with hybrid long-term care insurance. I'm insurance licensed in all states, and I also hold my Series 65 license with FINRA. And I created the company Ashbur to assist advisors and attorneys with pre-planning solutions as well as crisis Medicaid planning solutions. Today, we're specifically going to be talking about crisis planning solutions, but if you have any questions about pre-planning for your clients, feel free to reach out to me. How we can help you and your clients. We offer complementary case analysis. We can help you to determine the optimal amount to go into an annuity if you have a client that is looking to spend down assets for Medicaid qualification purposes. We assist in determining the optimal amount of the annuity, the term of the annuity, and which assets your clients could consider to annuitize. Specifically, if they have IRAs or existing life insurance or existing annuity policies that are going to be considered countable in your state, we can help with the actual converting of a countable asset into an income stream if your clients own those types of assets. We offer assistance from the beginning to the end of the case. We provide quotes for your client. We provide assistance with the actual funding of the annuity. And if your client does end up predeceasing the term of the annuity, we assist with the death claim process as well. We work with A-rated insurance carriers, and we offer top-notch customer service. We offer a very personalized approach to working with the law firms that we work with, and we offer a 24-hour turnaround time to get back to you with quotes and answers to your questions. So today we're going to be talking about specifically Medicaid, but if we look at the different ways that clients can pay for long-term care, the first option would be that they can privately pay or self-insure. This basically means that they can take money from checking, savings, IRAs, brokerage accounts, any assets that they currently have, they can liquidate those accounts in order to privately pay for care. We also can look at long-term care insurance for clients as a way to protect their assets against a long-term care situation. This can be either traditional long-term care, which is a pay-as-you-go type approach, and that is a use it or lose it type of contract where it's more like a term policy, whereas a hybrid long-term care insurance policy is going to be a permanent type of insurance, which is going to involve purchasing an annuity or a life insurance policy that has a long-term care rider attached to it, so that if the policy is not used for long-term care purposes, then there's going to be a death benefit that would be inherited by the intended heirs. Another way to pay for long-term care is the Veterans Aid and Attendance benefit. This would be available to any veteran or surviving spouse that has served 90 days of active duty, 1 day during a period of war. And this is going to be a cash benefit, a tax-free benefit that is available to veterans or surviving spouses if they are having to pay for long-term care expenses either at home, in an assisted living facility, or a nursing home facility. And then finally, we have Medicaid as the final way to pay for long-term care, which is what we're going to be talking about today. You'll notice on this slide that Medicare is not listed here as a way to pay for long-term care because Medicare does not provide a long-term benefit to pay for long-term care expenses. So that's something to note because there's confusion as to the difference between Medicare and Medicaid. Medicaid is a jointly funded federal state health insurance program for low income and needy people. Medicaid is going to provide benefits to children, to the elderly, blind, and/or disabled, and other people who are eligible to receive federally assisted income maintenance payments. Medicaid is based on federal law, but states interpret and administer the federal law. And although it's based on the federal law, Medicaid rules are going to vary from state to state. And in some states, it's different from county to county as far as how Medicaid is going to be administered and how applications are going to be treated from one county to another. Medicaid is not the same as Medicare, which is a national health insurance program for individuals that are 65 and older. One of the biggest differences is that Medicaid is going to pay for long-term care expenses, and it's a program where we need to basically impoverish somebody in order for them to be eligible for benefits, whereas Medicare is not going to be dependent on what a client's income or their assets are. It's simply based on work credits and somebody being over the age of 65. When we talk about what Medicaid planning is, Medicaid planning involves either spending down or otherwise protecting a person's assets so that they can meet the financial criteria for Medicaid qualification. And it can be divided into two different types. We have pre-planning or crisis planning. When we talk about pre-planning for long-term care or proactive planning for long-term care, this generally is going to involve a client that is not in need of any immediate long-term care services, nor do we anticipate them needing long-term care for some time. Generally, this is going to be somebody that is pretty healthy, that we're not concerned about them needing to pay for long-term care for at least a little while. Pre-planning is always going to be the best option for your clients because it allows them to preserve the most amount of their assets, and it also gives them more choice as to where they will receive care. And it often involves transferring the majority of the client's assets to an irrevocable trust and waiting out the 5-year look-back period for transferring assets or gifting assets. And it may also involve purchasing long-term care insurance, either a traditional long-term care policy or a hybrid long-term care insurance policy. If we look at what crisis planning is, this is usually going to involve qualifying the client for Medicaid or for veterans benefits. This is going to involve a client that is currently in need of financial relief from long-term care services that are already being provided or they're about to be provided. Somebody who is about to enter a nursing home or is going to go from the hospital into a nursing home is going to be somebody that is a client that we're going to do crisis planning for, because in the near term, we anticipate them needing long-term care, and those expenses are going to be high in most cases, as opposed to what the client currently has for income. There's various planning strategies that we can use to qualify a client for Medicaid or for veterans benefits. This generally is going to involve spending down countable assets in order to financially qualify for Medicaid or for VA benefits. And that's going to assist the client with qualifying for benefits and alleviating some of the long-term care costs that they're currently experiencing. The basic Medicaid eligibility requirements, we have non-financial and financial requirements. The non-financial requirements include the client being a U.S. citizen or qualified alien. We also must have somebody that is over the age of 65 or they are considered disabled. And then from a financial standpoint, which is what today's webinar is really focused on, is we must have somebody that has limited income and limited assets. When we have an individual client that does not have a spouse or they are not married, the income limitation for an individual is that their income must be less than what their cost of care is. And there is an exception in states where there is an income cap. In an income cap state, we must establish a qualified income trust or a Miller trust in order to have the client's total income be less than what the current cap amount is. And we're going to talk more about that. The asset limitation for an individual usually is around $2,000 of liquid assets that they can keep. This does vary from state to state. Some states like New York is significantly higher than other states, but the most common number is that we need to spend an individual that is not married or does not have a spouse down to $2,000 of assets or less. When we talk about a married couple, the income limitation, again, for the institutionalized person is going to be that their income must be less than the cost of care, unless we're in an income cap state. And then the community spouse or the spouse that is residing at home can have unlimited monthly income. There is not a cap on the amount that the community spouse is able to keep. From an asset standpoint for a married couple, the institutionalized person, again, is going to be able to keep around $2,000 in liquid resources, and the community spouse or the spouse that is residing at home in the community is able to keep 1/2 of the countable resources up to $137,400. This again is going to vary from state to state, but the most common number based on the 2022 updated figures is $137,400 in most states. First, we're going to talk about income, and then we're going to move on to the asset portion of the webinar. So when we look at what income is from a Medicaid planning standpoint, this is going to include gross income from all sources, both earned and unearned income. We may have a situation where a community spouse or a spouse that is residing at home is still working. In that case, we're looking at wages or self-employment income that is going to be considered countable income. And unearned income is going to be all other income from Social Security, pensions, retirement income, annuity payments, maintenance, disability insurance, support payments, basically anything that your clients would receive on a regular basis is going to be considered income to them when we're looking at income qualification for Medicaid. Income is attributed to the person whose name is on the check. If there are 2 names on the check, then the income is going to be allocated equally between each spouse. So if it's a joint income payment, then it's going to be considered 50% to the husband, 50% to the wife. For income purposes, states are either going to be considered a spend down state or an income cap state. The map that you're seeing on this screen here is showing the spend down states versus income cap states. The states that are in white are considered spend down states, and the states that are in orange are the income cap states. A spend down state is going to be a state which the spend down amount is the amount that must be contributed towards the cost of care after income allowances and exemptions have been deducted. If we look at an example where a client has income of $1,000, but the eligibility requirements only allow income of $800, then the client must incur an additional $200 in allowable expenses before qualifying for Medicaid. This, as a practical tip, is not really all that hard to achieve if we consider most clients are going to be spending significantly more money on a monthly basis in their care costs than what they have in income, which is why they're trying to qualify for Medicaid in the first place. So as long as their medical expenses exceed what their income amount is, they are going to be income eligible in a spend down state. If we look at an example of somebody spending $10,000 a month on nursing home care, which is a pretty average figure in some states that we work in, and they only have monthly income of $1,000 per month, they're going to meet the income limitation in a spend down state because they're spending way more in medical expenses than what they have in monthly income. An income cap state is going to be a state that imposes a limit on the Medicaid applicant's income. The current cap amount for 2022 is $2,523 per month in gross income. Any income that is over that cap amount of $2,523 must go into a qualified income trust or into a Miller trust before paying the nursing home in order to establish that that person is income eligible in an income cap state. If we look at an example of an income cap state, Medicaid applicant receives monthly income of $3,000, but the cap amount is $2,523. The applicant would not qualify for benefits because her income is $477 more than what the state income eligibility allows for. But if a Miller trust is established, the extra income of $477 could be deposited into the Miller trust before paying for the applicant's cost of care. As a practical tip, a lot of clients will have their total monthly income, not just the overage amount, deposited into the Miller trust. And that's really to make sure that the total income that the client is receiving is going to be less than the cap amount if it goes into the Miller trust on a monthly basis, and we're not risking that that client is not going to be considered income eligible if we just have all of the income go into the trust before paying for the cost of care. A qualified income trust or a Miller trust can be used interchangeably. It is a irrevocable income trust that holds the excess income over what the current cap amount is at $2,523. It must consist solely of pension, Social Security, and other income that the client has. This is not going to be a trust that holds assets that the client has. It's strictly going to be income going into the trust, and then that income is used to pay for the costs of care, usually in the same month. Any funds that are remaining in the trust must be spent on the applicant's care, and any sums that are remaining in the trust, if the Medicaid applicant passes away when they have that trust established, must be first used to repay the state for any Medicaid spent on their behalf. Okay, now we're going to talk about the income limitations or the income guidelines for a married couple. As we talked about, the institutionalized person's income must be less than their cost of care or less than the current cap amount of $2,523. The community spouse is entitled to unlimited monthly income, and if the community spouse does not have enough of his or her own monthly income to meet what Medicaid considers to be the monthly maintenance needs allowance, then he or she is going to receive a portion of the institutionalized spouse's income in order for the community spouse to pay their bills and not become impoverished. Any money that is remaining after the institutionalized spouse has shifted income to the community spouse is going to go towards the institutionalized spouse's cost of care or their patient pay amount. When we look at calculating the monthly maintenance needs allowance, or the MIMNA, this is going to be the minimum amount of income that the community spouse is entitled to keep when the institutionalized spouse is applying for Medicaid. This is a minimum amount that the community spouse can keep. This is not a cap on the amount that the community spouse is entitled to. States are either going to be considered a maximum state for purposes of the monthly maintenance needs allowance, or we consider them to be a range state where the community spouse is entitled to either $2,178 per month up to $3,435 per month. It's going to depend on what the shelter expenses are for the community spouse. Whereas a maximum state is just going to apply one standard amount that the community spouse is entitled to, and if they don't have that amount of income, then the income is going to be shifted from the Medicaid applicant. The map on the screen here is showing you which states are considered to be minimum maximum states or range states, and which states are considered to be a maximum state. You can see that more states on here are blue, which are the minimum, maximum, or a range state, whereas the states that are in orange on the screen are going to be just a set standard amount. They're entitled to the maximum MIMNA amount. If you're looking on our website for how your state looks at the MIMNA amounts, if you are looking on the state resources page, you'll see states that are considered to be maximum states are just going to have one figure listed, and that's going to be the $3,435 in most states. Whereas if you're in a state that has two numbers listed, a minimum and a maximum, then you are in a range state where the community spouse's shelter expenses are going to be taken into consideration when determining the MIMNA amount. We're going to look at a married couple situation of Robert and Nancy and go through an income example. First, we're going to look at a state that has a maximum MIMNA amount. Robert and Nancy are married, and Robert is about to enter a nursing home. Nancy is remaining at home. Robert has monthly income of $2,500, while Nancy has monthly income of $1,435 per month. Their state is a maximum state that says that Nancy is entitled to $3,435 per month. When we compare what the MIMNA amount is at $3,435 and what Nancy's monthly income is at $1,435, we see that she has a monthly income shortfall of $2,000. Because she has a shortfall each month of meeting her minimum amount of income that she's entitled to, the state is going to divert $2,000 of Robert's income over to Nancy, which is going to leave around $450 that is going to be paid towards Robert's income to be paid towards the nursing home. This is how the numbers work out here. First, we're going to determine Nancy's monthly income at $1,435. Then we're going to determine if there is a shortfall between Nancy's MIMNA of $3,435 and her current income at $1,435. We see that she has a shortfall of $2,000 per month. And again, this is going to be shifted from Robert over to Nancy before we determine what Robert's copay to the nursing home is going to be. Robert has monthly income from Social Security of $2,500. After we subtract out the amount that shifted to Nancy at $2,000, and then also Robert's personal needs allowance of $50, we see that Robert's patient pay or liability to the nursing home is going to be $450 after we shift some of his income over to Nancy to make sure that she has sufficient monthly income. If we now look at an example of a state that has a minimum amount of, or the minimum number is used for the MIMNA, the numbers are going to look a little bit different. Robert and Nancy live in a state that only allows for the minimum of $2,178. Then Nancy would only be entitled to $743 of Robert's income in this case. But if she can show that she has excess shelter expenses like a mortgage, utility bills, or other shelter expenses, then she may be able to receive more of Robert's income up to the $3,435. In this example, Nancy's income is going to remain the same at $1,435, but when we compare the minimum monthly maintenance needs allowance of $2,178 to Nancy's monthly income of $1,435, we see that she's only going to receive, in this example, $743 of Robert's income versus in that last example, she was entitled to $2,000 of his income. Robert's copay to the nursing home is going to increase in this situation because he's shifting less income over to Nancy. Robert had monthly income of $2,500, and when we subtract out the $743 that he is going to shift over to Nancy and his $50 personal needs allowance, then his copay to the facility is going to increase up to the $1,707 that he's going to pay towards his cost of care. If you are in a state that has a minimum and a maximum, or what we consider to be a range state, the community spouse is entitled to the minimum monthly maintenance needs allowance plus excess shelter expenses, but this number cannot exceed what the maximum is at the $3,435. Some of the shelter costs that we can look for when we're determining whether the community spouse is going to be entitled to the minimum or a greater amount of income is going to be if they're paying for rent or mortgage, principal and interest on a mortgage, if they have taxes and insurance for their principal place of residence. This also does include renter's insurance, any maintenance fee that the community spouse will be paying to live in a condo, and then also a standard utility allowance that the state is going to publish, which is also on our website. All of these expenses are going to be taken into consideration to determine if the community spouse is entitled to a greater amount of the institutionalized spouse's income when we are determining what the MIMNA figure is. Again, the monthly maintenance needs allowance should not be confused with an income cap because the MIMNA is not a cap. It's the minimum amount of income that the community spouse is entitled to. In pretty much every state, the community spouse can have unlimited monthly income without having to pay their income towards the institutionalized spouse's cost of care. In this example, if Robert and Nancy lived in an income cap state, A qualified income trust would not be required because Robert's monthly income was $2,500, and this amount does not exceed the current cap amount of $2,523. But if he had monthly income of, say, $3,000 and it was exceeding the cap of $2,523, then we would have to establish a Miller Trust if these clients were residing in a state that was an income cap state. Now we're going to move on to the asset portion of the webinar today. When we talk about Medicaid planning, assets are either going to be countable, non-exempt, or they are going to be considered protected, exempt, or non-countable. These are terms that people use interchangeably for describing countable versus non-countable assets, and we're going to go through what each of those mean. Countable or non-exempt assets are going to be assets that are counted towards Medicaid asset limitations. Protected, exempt, or non-countable assets are assets that are not counted towards Medicaid asset limitations. Some examples of countable or non-exempt asset for Medicaid qualification purposes include money that's in checking accounts, investment accounts, CDs, cash, real property other than the home, so like a vacation or a second home, boats, RVs. Some states do consider the IRAs to be countable or non-exempt, whereas some states do consider IRAs to be exempt. That's going to be a state-specific issue. Protected or exempt non-countable assets are going to include the home, a car, household goods and personal property, an irrevocable funeral trust or prepaid burial. And then again, some states do consider IRAs to be non-countable or an exempt asset that does not count against the clients for Medicaid eligibility purposes. When we're calculating the community spouse resource allowance, or the amount that the community spouse is entitled to keep and still obtain Medicaid eligibility for the institutionalized person, the community spouse resource allowance, or the CESRA, is the amount of countable assets that the community spouse is entitled to keep when the institutionalized spouse is applying for Medicaid. Like the MIMNA rules, some states do apply one standard amount or the maximum amount to the CESRA, whereas most states are going to be considered range states, and they apply a minimum and a maximum amount, generally between $27,480 and $137,400. The couple's total countable assets as of the snapshot date are divided in half, and we must stay between the minimum and the maximum amount when determining the CESRA amount. This map is showing you which states are considered to be range states or minimum maximum states. Those are all the states that are in blue. So most of the country does have a minimum and maximum, whereas a handful of states are going to be considered maximum states, where they just have one standard number that is used for purposes of determining how many assets the community spouse is entitled to keep. If you're looking on our website, you'll see that some states, if you are in a state that is considered to be a maximum state, it's just going to have one number. It's going to be the maximum community spouse resource allowance at $137,400. Whereas if you are in a minimum, maximum, or a range state, there's going to be a minimum amount. It's in most states $27,480, and it's up to a maximum amount of $137,400. We're going to look at an example of calculating what the CESRA amount is with the same clients, Robert and Nancy. Our case facts are that the couple owns a home, a car, and $200,000 of the following non-IRA cash accounts. Robert owns the following assets: a checking account at $25,000, mutual funds at $100,000, and Nancy owns the following assets: a checking account at $25,000 and stocks at $50,000. We're first going to look at a state that has the maximum CESRA amount. If we look at Robert and Nancy's assets of $200,000 and we're trying to calculate the CESRA in a state where the maximum amount is allowed, the current maximum is $137,400. We're trying to determine which assets or how many assets Robert and Nancy can keep. Robert, as the institutionalized spouse, is going to be able to keep his personal property, prepaid burial policy or funeral policy, and $2,000 of the $200,000. Nancy, as the community spouse or well spouse, is going to be able to keep the home, a car, personal property, a prepaid funeral policy, and because we're in a maximum state, she is able to keep $137,400 of the $200,000 in cash assets. When we add the $2,000 that Robert can keep to the maximum of $137,400, this couple has total exempt or non-countable assets of $139,400. When we subtract that number from the $200,000 that they have in countable assets, they're going to need to spend down around $60,600 in order to achieve Medicaid eligibility for Robert. When we're determining the spend down amount for a couple, we first determine what the countable assets are. We did that and determined that their total assets were $200,000. We then need to figure out what the exempt assets are in that state. Because we are working in a maximum state, the CESRA amount is $137,400. And then we're also going to take into consideration the institutionalized spouse resource allowance at $2,000. So their total exempt assets are $139,400. When we subtract the exempt assets from the countable assets, we determine that they need to spend down around $60,600 in order to achieve Medicaid eligibility for Robert. Next, we're going to move on to a state that is a minimum maximum state, and we're going to use the same total assets or countable assets of $200,000. If we look at a state that has a minimum and a maximum, we are looking at the 2022 CESRA figures where we have a minimum of $27,480 up to a maximum of $137,400. We're first going to take their total assets, total countable assets of $200,000 and divide that by 2. And we get a number of $100,000. Because that $100,000 is between the minimum and the maximum, we know that in this case, the CESRA amount is going to be $100,000. We calculated the spend down amount in this case of $98,000 by first determining which assets Robert and Nancy can keep, what's going to be considered exempt, and then subtracting that from the $200,000. Robert, as the Medicaid applicant, is going to be able to keep his personal property, prepaid funeral policy, and $2,000 of the $200,000. Nancy is going to be able to keep, again, the home, car, personal property, and prepaid funeral policy plus $100,000 of the $200,000. Their total exempt assets in this case are $102,000. When we add up the $2,000 plus $100,000, and their spend down amount becomes $98,000 in this case. If we consider another example where their total assets are $300,000 and we're still in a minimum maximum state, we would take their total assets of $300,000, excuse me, and divide that by 2. We determine that that number is $150,000 because the maximum community spouse resource allowance is currently set at $137,400. That's going to be the number that the community spouse is entitled to keep because that's the maximum, and that number is less than the $150,000 when we divide the total assets in half. In this case, the couple's going to have to spend down $160,600 before Robert can qualify for Medicaid. We calculated the $160,000 by taking Robert's $2,000 that he's entitled to keep of the $300,000 and adding that to the $137,400 that Nancy is entitled to keep as the maximum. Their total exempt assets are $139,400. Therefore, we need to spend down around $160,600 before Robert's going to qualify for Medicaid. The chart that you're seeing on the screen here is helpful in situations where you are in a state that has a minimum and maximum amount. If you look at the left-hand column, this is basically saying that if the total countable assets of the couple are $274,800 or more, like in our example of $300,000 in total assets, then the community spouse resource allowance becomes $137,400. And when you add the $2,000 asset limitation that the Medicaid applicant can keep, their total exempt assets are going to be $139,400. Whereas if we have a couple that has less than $274,800 but more than $54,960, they're going to be able to keep half of the total countable assets, and then you're going to add the half of the countable assets to $2,000 that the Medicaid applicant can keep. And then finally, if you have a couple that has $54,960 or less of countable assets, then the community spouse is going to be entitled to the minimum amount of $27,480. When you add the $2,000 that the Medicaid applicant can keep, that's going to give you the $29,480. So this is just a helpful guide if you kind of want to skip the dividing numbers in half to determine if the community spouse is entitled to the maximum or if they're going to use half of the total countable assets for the CESRA amount. One of the misconceptions about the community spouse resource allowance is that once the snapshot date has been established for the community spouse, that assets cannot be transferred in between spouses in order to spend down. This isn't true. We can transfer assets between a husband and wife without causing any transfer penalty as far as Medicaid qualification is concerned. If we have a situation where the wife is the one who owns most of the assets and she's the one that's going to end up needing care, there won't be any issue from a Medicaid standpoint of transferring the assets from the wife over to the husband without having any kind of penalty for Medicaid qualification purposes. If you have clients that have excess assets or assets that need to be spent down, we are going to look at developing a Medicaid eligibility plan. This can include increasing or improving non-countable assets. In our example, where a couple needed to spend down around $60,000 of assets, you may be able to achieve that by making home improvements, buying a new car if they need it, purchasing prepaid burial policies, if they have credit card debt, a mortgage, or other debt that needs to be paid off. You can consider all of those options in order to convert a spend down amount or a countable asset amount into non-countable. If there are still assets that are left over after all of these items are considered, then we can consider making exempt transfers. Some of the exempt transfers are non-penalized transfers. I'm just going to touch on these because Todd's going to go more in depth with these items next month, but we can consider transferring the home to a spouse, a minor or disabled child, or a child who's lived in the home for the last 2 years, helping to provide care. We can consider transfers to certain types of trusts, consider promissory notes with Medicaid qualifying language, or an annuity with Medicaid qualifying language. The language that must be contained within a Medicaid compliant annuity is going to be that the annuity must be completely irrevocable, non-assignable, make equal payments, be actuarially sound, and name the state Medicaid agency as a remainder beneficiary in the event that the annuity owner would predecease the term of the annuity contract. The planning opportunities that are available to individual clients that we are trying to spend down to $2,000 or less in resources are going to usually include making a gift and purchasing an annuity, or making a gift and doing a promissory note, or in some states doing a gift and doing a partial return of the money. And then a second option would be to do a standalone annuity or promissory note in the case where we have an individual that has a limited life expectancy. The planning opportunities that are available to married clients are going to, again, include either doing a Medicaid compliant annuity or a promissory note. Some states allow us to get a CESRA expansion or get a increased amount up on top of the $137,400 that is the current maximum, if we can show that the community spouse has more of a need for additional assets above the $137,400. And then there are still a handful of states that do allow for spousal refusal, for the community spouse to essentially refuse to pay for the Medicaid applicant's cost of care. And then some states do allow for a sole benefit trust in order to spend down countable assets to achieve Medicaid eligibility for the Medicaid applicant. Again, we're going to talk more about those topics next month. Attorney Todd Watley of Arkansas is going to be our guest speaker next month to talk more in depth about Medicaid planning techniques that can be used in order to best plan for your clients. Todd is a certified elder law attorney with 20 years of experience as an attorney practicing in elder law. He is a past president of the National Elder Law Foundation, and he has created, managed, and sold 3 law firms in the state of Arkansas. He's of counsel for a number of law firms across the country, and he is a national speaker and educator on different elder law issues. I'll go ahead and answer any questions that people have on any of the content that we went through. Somebody is asking if the monthly maintenance needs allowance only applies to married couples, and the answer is yes. If we have just a Medicaid applicant that does not have a spouse, we, from an income standpoint, are just looking to see if the Medicaid applicant's total income is less than their cost of care, or if it's less than the current cap amount if you're in an income cap state of the 25-23. So the monthly maintenance needs allowance is only going to apply in situations where we have a spouse that is residing at home and we want to make sure that the community spouse has enough of his or her own monthly income to meet their expenses. Somebody is asking, can you remind me where the presentation slides are? You should be seeing on the GoToWebinar dashboard a handouts portion on the screen, and the title of the PDF should say Medicaid Basics. If you're not able to find it, I can email the slides over to you. Somebody is asking, what is the process when the Medicaid applicant has passed away prior to the Medicaid application being approved? An annuity was purchased, Medicaid app was filed in October, and she passed away this week. Usually, if the state Medicaid agency is listed as a primary beneficiary on the annuity and the annuity owner has passed away within the time frame of the annuity, you would need to notify the person that you purchased the annuity from, or that insurance company, notify them of the passing of that client, and then a clearance letter would be obtained from the state Medicaid agency, just basically aligning that that client has never received a Medicaid. And then once that clearance letter is received from the state Medicaid agency, then the secondary or contingent beneficiaries that were listed on the annuity application would be entitled to receive payment once that letter is obtained from the state Medicaid office. Okay, the majority of the other questions, it looks like, are state specific, which I can reach out to you specifically to answer questions on the state specific questions. I'm not seeing any other questions here, but if you think of any questions, feel free to give us a call or shoot us an email using the contact information on the screen. Again, please join us for our February webinar. It's going to be very informative, and I believe it's February 9th that we're going to be doing that webinar, but you will receive an email notification about it. And I want to thank everybody for being with us today. If we can help you with anything, please feel free to reach out. Thank you and take care.